Good morning. The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Yes.
Representatives Andrews.
Here.
Carter.
Present.
Breen. Young.
Here.
Arbit.
Present.
Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat. Harris.
Here.
Bagol.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the May 30th meeting. Without objection, the minutes are adopted. And we will now hear testimony on House Bills 4474, 4475, and 4476, and 4477. Representative Arbit, if you'd like anyone to join you at the table, please feel free to bring them up.
Thank you, Chair Hope and members of the committee. It is an honor to address you this morning about this critical legislation to strengthen Michigan's response to rising hate crimes. Hate violence is carved out in the law because it is terroristic in nature. There's never just one victim of a hate crime. An entire community is victimized too. Hate crimes tell all those who share a victim's identity, people like you aren't welcome. People like you don't belong. People like you are not safe. I introduced this legislation because, as a proud Jew and a gay man, I will not sit idly by and watch as the communities I am part of continue to be threatened by rising hate crimes. Michigan can be so much better. In 1982, two white auto workers who blamed Japan for turmoil in Michigan's auto industry murdered Vincent Chin, a Chinese-American man, at a bar in Highland Park. Vincent Chin's brutal murder sparked a nationwide movement to enact state hate crime laws. In 1988, the legislature passed Michigan's Ethnic Intimidation Act, but it hasn't been amended even once since its passage, 7 years before I was even born. In the 35 years since, Michigan has seen an unabated rise in hate crimes, with no corresponding legislative action to address it. Reported hate crimes and bias incidents have increased almost every single year in the past decade, while Michigan's legal architecture remains stuck in 1988, failing to account for best practices developed across the country. That's why Representative Grant and I have introduced House Bills 4474 and 4475. The Michigan Hate Crime Act expands the basis on which hate crimes can be charged to include several categories missing by the current law, including sexual orientation, gender identity and expression, physical or mental disability, ethnicity, and age. To put a finer point on it, crimes targeting individuals or property motivated by sexual orientation, which are the second most common type of hate crimes in Michigan, cannot be prosecuted under current law. The same is true of hate crimes targeting people with disabilities and crimes targeting seniors. The fact that gay Michiganders with disabilities, and seniors are still unprotected from hate crimes in Michigan law is egregious and intolerable. The Michigan Hate Crime Act rectifies this wrong. It is vital to understand that as my bill protects gay people, it also protects straight people. As it protects Jews, it protects Christians. As it protects black people, it protects white people. As it protects women, it protects men. It is not just minority communities who are targeted for hate crimes. It doesn't matter what percentage of the population your group comprises. No Michigander should ever feel unsafe or threatened because of who they are or the community they belong to. Additionally, the Michigan Hate Crime Act recognizes the need to address hate crimes that are particularly severe, which is why, in addition to retaining the 2-year felony in current law, it adds a maximum 5-year penalty for felony hate crimes presenting with aggravating factors, which are enumerated in the law. Finally, and crucially, the Michigan Hate Crime Act allows for an alternative sentencing option consisting of community service for hate crimes with aggravating factors. This provision serves as a starting point for further efforts towards restorative justice for hate crimes, including diversionary and treatment programming, all of which I'm excited to work on with Representative Devendorf this session. House Bills 4476 and 4477, introduced by myself and Representative Puri, comprise the Institutional Desecration Act, which prohibits the defacement, destruction, and vandalism of institutions and communal property, including but not limited to houses of worship, community centers, business and nonprofit headquarters, and enumerates these crimes as hate crimes. The Institutional Desecration Act provides a more appropriate tool to pursue justice and accountability for hate crimes targeting faith-based institutions and other types of communal property, which have skyrocketed in Michigan, as we've seen in the Rochester Hills Mosque that was vandalized in late 2021, and most recently, the Woodward Avenue Synagogue in Royal Oak, which was vandalized with a swastika just last month, only 4 days after we introduced these bills. While these crimes are typically prosecuted under malicious destruction of property statutes, there are a number of deficiencies with that approach, which makes passing the Institutional Desecration Act so vital. Indeed, Michigan is only one of 15 states in the nation without a similar statute on the books. While I want to acknowledge how vital this legislation is, I also want to acknowledge its limits. Hate is a social ill that we need to tackle as such, and this legislation is no substitute for that work. No matter how much I wish it were otherwise, I cannot write a bill that gets rid of anti-Semitism or anti-Black racism or anti-Asian racism or homophobia or Islamophobia. What we can do is tackle hate when it dovetails with the criminal act. What we can do is improve Michigan's tools to respond, pursue justice and accountability, and create opportunities to reduce hate violence. That is what these bills will achieve, and that is why they are so crucial. Together, we can demonstrate that Michigan's justice system will treat hate crimes with the seriousness and severity that they are due. Now is our moment to send a message that we will not tolerate hate crimes anywhere in the state of Michigan. I thank you for your time and will now turn it over to our extraordinary Attorney General, Dana Nessel, who has spent her career fighting hate crimes and without whose partnership we certainly would not be here today to testify on these bills.
Thank you so much, Rep. Arbit, and it's an honor and a pleasure to be here testifying before all of you today. Thank you, Chair Hope, Vice Chair Andrews, Minority Vice Chair Filler, and all the other members of the committee. I just want to note that I have a number of people who are here with me today. One is LaDonna Logan. She is the head of our hate crimes and domestic terrorism unit. Ann Sherman, my Solicitor General, who is one of the foremost experts in First Amendment law. Mitch Albers, also our Director of Legislative Affairs, and some other folks as well today, too, who may be able to answer any questions that potentially I can't. But with that, let me say this. Michigan has historically been a consistent leader in the effort to protect civil rights of the residents of our state. And we continue that effort today by reviewing, updating, and amending our state laws to ensure that they properly reflect the issues that our state is currently facing and the crimes that county prosecutors and my department are seeing on a daily basis. Now, when the Ethnic Intimidation Act was passed in 1988, it was a bipartisan response to, as you heard from Rep. Arbit, the brutal murder of Vincent Shin. Notable stalwart supporters of the Ethnic Intimidation Act included Governor John Engler and Lieutenant Governor Connie Binsfeld. So I've spent nearly 30 years practicing criminal law in this state, half that time as prosecutor, the other half as a defense attorney. In 2016, in response to the exponential rise in hate crimes committed against the LGBTQ community, together with Wayne County Prosecutor Kim Worthy, we established a first-of-its-kind project called the Fair Michigan Justice Project, where we exclusively investigated and prosecuted hate crimes. And that project has charged 28 cases, most of them incredibly serious: murders, assault with intent to murder, carjacking, armed robbery, CSC cases. So far, it's obtained 26 convictions. There are 2 that are awaiting trial. In 2019, as Attorney General, I established the first hate crimes and domestic terrorism unit of any state AG's office in the nation. We've reviewed 125 complaints. We've authorized 13 cases. We have 12 convictions. 1 case remains pending. So that's all to say that I've learned a lot about hate crimes in the last 30 years or so. And here's some of what I have learned and what I know. Firstly, as Rep. Arbit indicated, these are some of the most disturbing types of cases. Again, not just because they target an individual, but because the real intention is to target an entire community of people and instill them with fear. Hate crimes continue to be on the rise, both nationally and here in the state of Michigan. The FBI recently recorded a 31% increase in hate crimes in just a single year. Michigan is 5th in the nation per population in terms of the number of hate crimes that are committed. Hate crimes are historically and significantly underreported. Only an estimated 3 to 10% of hate crimes are actually reported. Now, why is it important to have robust hate crimes laws in this state? And as to, say, for instance, the crimes that I just mentioned, like we can charge murder. Why do we need hate crime? We can charge attempted murder. Why do we need a hate crime? Well, very simply, it's because of this. These hate crimes laws are murder prevention. The several dozen very serious bias-motivated homicides and attempted homicides, tortures, AWIMs that I've dealt with, the defendant didn't start off killing people or trying to kill people. There were always less serious assaults or sometimes property damage that occurred which predated the murder offense. And these were cases where if there had been judicial intervention and that had occurred earlier on, and that person had received treatment or been under the court's supervision, the latter and more serious event would have been much less likely to have occurred. Not nearly enough categories of protected classes are listed in the current Ethnic Intimidation Act. And some of our most targeted, vulnerable populations are currently not protected. Crimes against the disabled, crimes against the elderly, who have some protections under the law, but many of the laws that we currently utilize in order to prosecute those who commit heinous crimes against the elderly cannot be utilized. And for instance, prosecuting a vulnerable adult case requires that the defendant be a caregiver. That wouldn't be true in this instance. Obviously, the disabled have been targeted a lot, as well as the LGBTQ community and others who are not currently protected. A 2-year offense for the most serious and dangerous forms of hate crimes is simply not enough. Well, why is that? Well, I have a number of reasons. Firstly, you cannot habitualize a 2-year offense. So for a person who commits this crime over and over again, they cannot be habitualized under a 2-year. It has to be a higher level offense. Firearms possession. As we've talked about a lot, many of you know, and this isn't related to hate crimes, but you've all heard about Anthony McRae and how he was able to legally purchase firearms because he had been convicted of a 2-year offense. Someone who commits a hate crime after they're off probation can then go and legally purchase and possess firearms. Not so if they are convicted of the more serious 5-year offense, if there are aggravating factors. Competency issues. Nobody ever thinks about this, but it's very, very important. With only a 2-year offense, instead of getting the full 15 months for an individual to have the ability to be made competent, the court has only 1/3 of the potential sentence. So that's 8 months for a person to become competent who has mental health issues. And I'm going to give you an example. Hassan Choker, the case that's pending right now in Oakland County, who allegedly threatened children and their parents on the way to Sunday school. If he's not found competent in just 8 months, then he's going to have to be released. And with no mental health services, nothing. He will just be released instead of being able to wait the entirety of the 15 months for him to be made competent, which often is necessary. Felony firearm. Sometimes felony firearm is important. Sometimes it has to be charged when you have a really serious set of circumstances where you have an individual who has committed a hate crime and has utilized a firearm in that process. Can't be added to a 2-year, can be added to a 5-year. Hate crimes are virtually never prosecuted under federal law. And the instances in which the feds can prosecute are very, very limited. There needs to be a federal nexus. The defendant has traveled across state lines. There has been an instrumentality of interstate or foreign commerce used. or the crime occurred on federal territory or in maritime jurisdiction, so on a cruise ship, I guess, or something. It's almost never charged. We almost never see that. Ethnic intimidation acts have been, this offense has been charged an unknown number of times. Myself, just personally, I've charged it and defended it hundreds of times. Prosecutor Worthy, it's got to be in the tens of thousands since you've been in office. It has always been found to be constitutional, has never been found to violate the First Amendment. Constitutionally protected speech will continue to be constitutionally protected speech. And these bills, we've done a significant amount of review in our department, and they will withstand judicial scrutiny. We've also seen a significant increase in property-related offenses, targeting houses of worship recently. 260 incidences of vandalism of Catholic churches in 43 states in just the last year and a half. The time is now to act. Our state desperately needs better, stronger, more extensive protections for some of Michigan's most vulnerable and targeted communities. All of you here today, you have the ability to literally save lives, and I respectfully ask you to pass these important laws to protect those in our state who need that protection the most.
Thank you for having me. My name is Kim Worthy. I'm the elected Wayne County prosecutor, the largest county in the state by far. We do about 65% of all the criminal cases in the state. If you take the other 82 counties and add them up, we do more cases than the other 82. My responsibility as the chief law enforcement officer of Wayne County is obviously to keep my citizens safe. For almost 12 years as assistant prosecutor and almost 9 years on the bench at the Wayne County Circuit Court, and then this is my 19th year, I believe, serving as the Wayne County prosecutor, I feel at times I cannot properly represent my constituents because we don't have the tools as prosecutors to protect people from certain crimes. I don't know about you, but it feels you feel very bad for weeks on end when you look at someone who's been terribly brutalized, someone who is scared, someone who's been the victim of a hate crime, and you look them in the face and tell you because of Michigan's law, there's nothing I can do for you. And we have to live with that. These bills will help us with that. There have been some egregious cases in our hands in our county where our hands were figuratively tied behind our back, and we were not able to dispense justice in the proper way. Again, we didn't have the tools. As a state, we really need to ask ourselves, are we really invested in protecting every single Michigander? Or are we only invested in protecting some of them? Now, of course, I'm talking about the hate crimes legislation that has been nicely laid out by my colleagues here. And I'm talking about crimes that protect all these classes. Of course, race or color, of course, religion, sex, sexual orientation, gender or identity expression, physical or mental disability, age, and the representative has already talked about the new ones that were added, ethnicity, and national origin. This set of bills will give us the tools as prosecutors that we need for something that's currently unworkable. The rise in hate crimes is real. I'm not going to quote any stats. Maybe someone else will do. And the things that have been happening certainly were not considered as bad as things are back in 1988. These bills will do the following. They will give prosecutors, and again, I should say, and I should have said from the onset, I'm here representing also the Prosecuting Attorneys Association of Michigan, where we support this legislation. It is bipartisan. As a matter of fact, of the 83 counties, only about 16 of us are Democrats. So this is bipartisan. So some of the tools that will help us across the state with these bills, it adds classes of people that this has been talked about that need to be protected, including our seniors and those Michiganders with disabilities. Who among us don't have grandmothers, grandfathers, or people that we know with disabilities that we would be outraged if they couldn't be protected? It makes it easier to prosecute real hate crimes, especially when it comes to property and assaults. It sends a message that hate crimes are absolutely intolerable in this state. It also increases the penalties, as the Attorney General has said, under certain circumstances, 2-year offenses to 5-year offenses. It also talks about the following aggravating factors, which is also very important. These aggravating factors are as follows. The violation results in bodily injury or severe mental anguish. That is a big bulk of the cases that we see that we cannot charge now. The person has one or more prior convictions for violating these subsections. Third, a victim of a violation of the subsection is less than 18 years old. In other words, we're protecting our children. And if you commit a hate crime against a child, it's an aggravating factor, as it well should be. The person commits in violation of this subsection when they act in concert with other individuals. I want to analogize this to the sexual assault things that we already have on the books. It's bad enough when someone is assaulted in the most intimate of ways. It is worse when that person has a weapon. It is worse when it's a gang rape situation that's by more than one person. It is worse when it's a child under the age of 13. So certainly we already have such protections and aggravating factors in Michigan, but again, these aggravating factors mirror in most ways our sexual assault statutes that are already on the books. So in a nutshell, please, these factors make crimes much, much worse. Imagine you have an 8-year-old child that's a victim of a hate crime, and we have the non-penalties that we have today. And again, this is critically important. In sum, the Michigan Hate Crime Act is an extremely useful tool for prosecutors. Again, we don't have the current tools in our toolbox, and I'm really, really tired after almost 40 years of doing this as an assistant prosecutor, as a judge, and now as the elected prosecutor, telling people that Michigan doesn't have any laws that can help them in any way. Go back home. I'm sorry you were a victim, but there's nothing that we can do for you. We also, as we've already laid out, this is an important expansion of our current ethnic intimidation statute, which, as I had mentioned earlier, is woefully inadequate. It was well-intentioned at the time, but it doesn't help us address hate crimes across the board. The new Hate Crime Act will help us protect our citizens and deter acts of violence that result from bigotry and backwards mentalities. So again, I cannot stress enough, as someone who is in the trenches every single day, and I have been in some capacity for 40 years, we have to protect our victims of hate crimes. We have to let them know that this is serious. We have to let them know that they can be safe in this state. We have to expand our laws so that the person that victimizes them in any way can be held accountable. It's critically important. And you don't want to be that person that's looking, and one of my constituents is here, and she's going to talk. You don't want him to be that person that looks them in the eye and says, Michigan doesn't have the tools for prosecutors to help you. And so therefore, the person that did this got away with it. It's not important. We don't make it a priority. Please pass these set of bills. Thank you.
Thank you. We do have some questions, and I want to let representatives and the audience know that we will be shifting gears here and going on to a different topic at 9:35. There's no wiggle room, but if we have time after we take our votes, we will resume testimony on this. Representative Breen.
Thank you, Madam Chair, and thank you to the three of you for your testimony. And I think it's important to note that you've already rebutted, I think, some of the main arguments that you hear against hate crime legislation, specifically murder is murder. But what you are discussing is that, and when it is a hate crime, it is not against a singular person, but an entire community. And you are not just people who are testifying as lawmakers, you are colleagues, you are friends, and being from the Oakland County area, where one of our other colleagues has a very large Jewish population, she is constantly in tears because of the threats that are made against the Jewish community. We're talking swastikas that are on strollers. What is happening right now is on the rise, especially in Oakland County, and I hate to see what it is doing to everyone. You also mentioned the lack of prosecution at the federal level, but one thing that I think sticks in a lot of people's minds is that you cannot legislate how people feel. And a large component of this, I think, he needs to be addressed through education and building empathy. Within the bills, I believe there was a section, maybe you can elaborate on this, on what we can do to help build that empathy and help people become educated in order to help avoid these atrocious crimes in the first place.
Thank you, Representative Breen. And yes, I share your concerns. And in my testimony, I did say that, hate is a social ill, and these bills are no substitute from tackling hate as a social ill. And I'm looking forward to working with Representative Devendorf, the Attorney General, about what different types of programming can we put in place in terms of diversion, in terms of treatment, in terms of different types of off ramps from this type of violence that is motivated by bias and hate, and produces just this sort of extreme reaction, right? In terms of a violent act. We're not criminalizing hate here. We're criminalizing hate when it dovetails with a criminal act, right? So that's what we're prosecuting.
Yeah, and I would just say in response to that, there are programs across the board, whether you're talking about, the programming that Mothers Against Drunk Driving put together, so that people better understand the consequences of drunk driving, whether it has to do with John Court, which we had in 36 District Court, may still be there, where people understand that when you are soliciting a prostitute, that person, that sex worker, may not be there voluntarily, and you learn about the fact that many of those people are trafficked, so that you gain a better understanding of your conduct. And we have those, and obviously we have anger management, we have batterers counseling, we have all kinds of different programming available for different kinds of conduct. We can do the same here, and there are groups out there that are working on that as we speak. But the point that we make also in these, through this legislation is, listen, we can't make you like people who are different from you, but we can make you understand you have to tolerate people's differences, and you cannot commit crimes against people who might be different from you.
And if I could just give you an example, Representative, about something you mentioned about murder is murder, et cetera. We have families, and I'm sure it's not unique to my county. For example, and I won't say too much about the facts because this case is pending, but we had a case where a man drove a car into a group of Muslim citizens from the road all the way to the beach and struck a girl, I think she was 16 years old, and we could not charge ethnic intimidation in that case. We did charge murder, but having to sit down with the family and explain to them that Michigan doesn't have a law in the books because, of course, she was, according to the facts allegedly, she was targeted because of who she was and how she was dressed because of her religion. And so, again, even though you're able to have those tools, that doesn't show that we tolerate hate crimes in the state because we don't have any tools. So that is a situation where the family is still having a hard time understanding, why couldn't you charge a hate crime? We don't have the legislation. Why couldn't you charge ethnic intimidation? Because we can't prove that beyond a reasonable doubt in court. But clearly, allegedly, that were the facts in that case. And we have many stories like that to tell.
Thank you very much. I very much look forward to voting this through.
Very quickly, Rep. Filler.
The original bill mentioned intimidates or harasses an individual, which is a hate crime under the new legislation. I believe that's been struck in the H1. Could we just have some discussion?
Nope, it won't. It intimidates is still there. The order has been swapped. You'll see it's right at the end there. But yeah, we did remove the word harass for clarity's sake.
What's the clarity necessary?
Well, we wanted to tighten up the definition to ensure that we were not, over inclusive of, constitutionally protected activity. So,
thank you.
Yep.
Thank you. It is 9:35.
Thanks for having us. Much appreciated.
Thank you. We will now hear testimony on Senate Bill 90. Senator Anthony is here, I believe. And please get started whenever you're ready.
Thank you, Chairwoman Hope, and colleagues. Good morning. Thank you for allowing me to share a few moments to talk about an issue that I've been fighting for since 2019, the Crown Act. This has been a long time coming. It's something that men, women, and children across the state of Michigan have lifted up as an issue that is often overlooked and is unique to many African Americans throughout the state of Michigan and across the country. For those of you who are not aware, CROWN stands for Creating a Respectful and Open World for Natural Hair. I first introduced this bill in 2019 without a single co-sponsor. This was my first full term in the Michigan legislature. As you know, the Elliott Larson Civil Rights Act prohibits discrimination in the workplace at all levels of education, in public accommodations and services, and in real estate transaction. Senate Bill 90 would update Elliott Larson to prohibit race-based hair discrimination or the denial of employment and educational opportunities because of hair texture and protective styles. Protective styles can look like anything from braids, twists, locks, things, again, that protect the natural texture of African American hair. To note, before you is S1, which is a version that essentially is a technical fix. It reflects the amazing work we did this term in Public Act 6 of 2023 to expand opportunities for our LGBTQ men and women in Michigan. Individuals from all walks of life have reached out to our office and shared real stories of hair discrimination, which we know is thinly veiled racial discrimination. We've talked to individuals who have been passed over for promotions and terminated because of their hairstyles were deemed unprofessional or unkempt. Men and women who have been neglected and passed over for health care in hospital settings because their locks were deemed gross or dirty. And healthcare professionals have told them that despite the fact they had an open head wound, that they did not feel comfortable providing them with health care. Some of the most heartbreaking stories we have heard are from children right here in the state of Michigan. A young woman, a young girl, right, an elementary school girl was told she could not take her school pictures, was told to get out of the picture line because of her braids. A young girl in Mount Pleasant, Michigan, went to school one day and a school staffer cut her hair without her parents' permission. Her curls were cut. Her father has since said that her hair texture has never quite recovered from this. In 2020, studies conducted by Michigan State University and Duke University revealed how prevalent this issue is. It confirmed that hair discrimination was not something that was in the mind of African Americans across the state. This research showed that Black women with natural hair are often seen as unprofessional and less competent. Think about that. Our hair has determined how competent we are, how worthy we are of promotions and of job opportunities. It's clear that the mental and emotional toll this has taken on real Michiganders can no longer be ignored. But fortunately, today is a new day. Again, despite 2019, it being sent to the legislative graveyard, 2021, it not being provided a hearing. Thank you to Chairwoman Hope for giving it a hearing. Despite the inaction in the legislature, local communities across the state have taken action to enact their own Crown Acts. Right here in the city of Lansing, Ingham County, Ann Arbor, the city of Detroit, Oakland County, Flint, Genesee counties have all lifted up their voices and said that they will not prohibit hair discrimination, or, well, they will prohibit hair discrimination. In addition, the State Board of Education recently adopted a resolution in support, and I'm pleased to inform you that the State Senate overwhelmingly supported the passage of the Crown Act, both Republicans and Democrats, so a bipartisan effort. It's long overdue that we finally stand against this thinly veiled racial bias and enact the Crown Act to end hair discrimination in Michigan. Thank you for the opportunity, Madam Chair.
Thank you. I believe we have someone on Zoom who would like to testify. Mr. Asamoah? Ms. Asamoah, I'm sorry.
Can you hear me?
Yes, ma'am.
Okay, thank you so much. Good morning, Chairwoman Hope, distinguished members of the committee, Senator Anthony, and all those who are assembled both virtually and in person. Madam Chair, thank you for the opportunity to testify in support of Senate Bill 90. My name is Adjoa B. Asamoah. For the record, that is spelled capital A, lowercase d, J-O-A, space, capital B, capital B period, space, capital A, lowercase S-A-M-O-A-H. And I am here in my personal capacity, not as a lobbyist because I am not one, but as the lifelong racial and gender equity champion who conceptualized the Crown Act, developed the legislative and social impact strategies for it, and who leads the nationwide movement to outlaw race-based hair discrimination. For all intents and purposes, I am known nationally as the Crown Act champion. And again, I'm grateful to be here with you all this morning. There is a long-standing history and problematic practice of racial discrimination based on hair. In many ways, anti-Blackness is pervasive, and while race is certainly a social construct, racism is very real, and it requires a thoughtful and intentional and collective approach to dismantle the very rules and practices that reinforce it. There have been countless cases where Black people have been discriminated against for wearing natural hair and/or protective styles, including but not limited to locks, braids, twists, bantu knots, afros, etc. This prevalent form of discrimination includes, as Senator Anthony mentioned, being fired, passed over for promotions, and even having offers of employment rescinded. It impacts the upward mobility of individuals and families, and it has been the reason that far too many children have missed school or had negative educational experiences. In recognition of the time limit, but just to reference a few, I lift the names of Faith Finity in Louisiana, who was sent home in tears because she was told that her beautiful braids were deemed a violation of school rules. I lift the name of DeAndre Arnold in Texas, who I had the pleasure of testifying with, where the bill just recently was signed into law. He was told that he could not participate in his high school graduation ceremony with his friends, all because he wore locks, which for him was a great sense of ethnic pride. Lastly, I'll just lift the name of Andrew Johnson, a student wrestler in New Jersey, found to be worthy of the match based on his talent, but forced to make a decision that nobody, especially no child, should ever have to make. And that was to decide on the spot to either forfeit a match he had again earned the right to participate in based on talent, or to again have his identity attacked and have his locks cut right there on the mat. These purportedly race-neutral grooming and dress code policies in the workplace that reinforce a Eurocentric image of professional hair are problematic. Eurocentric beauty standards that continue to perpetuate unfair inequity and injustice in workplaces and schools, most often against Black people for wearing hairstyles inherent to racial identity, are also problematic. This warrants a legislative fix. The Crown Act is that fix. Senate Bill 90 will outlaw race-based hair discrimination by extending statutory protection to both hair texture and protective styles. Now, I wear quite a few hats, or dare I say crowns, and I lift one more of those just because it's applicable. I am also a former adjunct psychology professor and still a licensed clinician, and I started in K-12 education. I share that only because I know the harm that negative school climate and culture can do to a child. The psychological impact of being told that the way you were born, the way you look is not okay, is something no person should have to endure, especially our babies. By now, you have likely come across the NIH study noting there is a correlation between the use of chemical relaxers and the increased likelihood of developing uterine cancer and fibroids. The data are clear. There are psychological, physical, and economic impacts here. Today, my hair is natural, meaning without chemicals but blown out. When I switch it next week to rock twists, as I often do, I am more likely than others who are not Black to be discriminated against. Same person, different hairstyle. There is so much more I would like to share, but my time is coming to an end, so I will simply note this work is my brainchild. I am simply working to protect and preserve our rights to rock our crowns how we see fit, whether it's natural, again, meaning without chemicals, but blown out, or curly, like mine was last week, or in the twist again that I'll have next week. Senator Anthony, I thank you for your leadership for years, your partnership, and for championing this effort in Michigan, and for having me here today on behalf of the many organizations that I brought into the Crown Coalition. I ask you all to vote favorably on SB 90, and I am happy to answer any questions.
Thank you. We do have a question. Representative Filler?
Thank you, Senator. Good to see you. Can you just walk me through what this looks like legally, as in maybe an individual who believes they were discriminated against because of a hairstyle right now does not have a place to go, and this would give them a place to maybe file suit or file a civil claim of some sort?
Thank you, Representative.
To be
Good seeing
clear,
you.
the burden of proof is still on the person who believes that he or she was discriminated against. I want to make the distinction between hairstyle and protective hairstyle or hair texture. If, for example, you were to, rock a mullet and feel like you were discriminated against for rocking your mullet, or a lime green ponytail, that is not what the Crown Act is being put in place to protect. Those are, your rights as an individual, but we are arguing that hair is a racial characteristic. So that, therefore, we are talking about hair texture, or in the protective styles, again, by meaning braids, locks, twists, bantu knots, etc. So it's not just hairstyles. There are hairstyles that, people wear that are not affiliated with race, and then there's racial discrimination. So when you say legally, that means that if someone is discriminated against for wearing their hair in alignment with their racial identity, and then they are discriminated against, then that person has the right to go and file a claim, but it is racial discrimination, not just hair per se. Does that help?
Sure. Thank
Sir?
you very much.
Thank you.
Representative Young.
Thank you. Thank you, Senator Anthony, for bringing this forward. You left me and went to the Senate, so I couldn't be a co-sponsor this year, but I'm still excited to support this legislation. Having known people who have been discriminated against because of their hair, it's a real thing. And it was really disheartening when you had your press conference. It's so silly we're talking about hair, but it was really disheartening when you had your press conference and I read the comments of, oh my God, we fixed the state, we're worried about hair. When I read the comments of, that's all y'all can think about doing in Lansing. But then when you know that there are people who've been fired because they refuse to conform, because they refuse to straighten their natural hair. See, it doesn't affect everybody. It doesn't affect my colleague to the right of me. It doesn't affect my colleague to the left of me. But it affects folk like us. And so it might not be everybody's situation, but it's a real thing. When you look at the officer who was put on administrative leave because he wore cornrows, you're like, wait a minute, I was just recognized for being one of the best in the department, but because I changed my hair, now I become the least of these? It may seem like a small thing, but it's huge for people who experience it. And so for that, I just want to say thank you.
Thank you, Representative.
Seeing no more questions, we're going to do something somewhat out of the ordinary for this committee. First of all, I should mention we have several cards that will be recorded in the record. And we will now vote on Senate Bill 90. Representative Young moves to report Senate Bill 90 with recommendation. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Aye. Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat. Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. Senate Bill 90 is reported with recommendation.
Thank you. Okay. We will hear some brief testimony now on House Bill 4173 and House Bill 4384. We're looking at substitutes, and here to testify in support of the subs is Representative Ayash's Legislative Director, Trent Wolf. Go ahead and get started when you're ready.
Good morning, Madam Chair and members of the committee. Thank you so much for taking up the proposed H2 substitutes for House Bill 4173 and 4384. As the Chair said, my name is Trent Wolf, and I serve as a Senior Advisor to Majority Floor Leader Ayash. Couldn't be here this morning. and asked that I provide some quick testimony in regards to the changes that have been made in regards to the H2 substitutes. As you all know from the last committee hearing on this legislation, the Michigan Sentencing Commission is designed to provide policy recommendations to the legislature regarding Michigan sentencing guidelines. First, the first major change we wanted to outline with the bills is that we split the bills in two and tie-barred them to Rep. Meerman's House Bill 4384. So House Bill 4173 now contains Section 34A, which relates to the makeup of the Michigan Sentencing Commission, while House Bill 4384 contains Section 34B, which outlines the tasks required of the commission. The original legislation had 17 voting members, while the H2 substitutes in front of you reduced the size of the commission to 15, with only 10 of them being voting members. The substitutes removed a criminologist, a district court judge, community corrections representative, and a representative from the counties, and added a second circuit court judge, a victim's advocate, and a mental health professional. In total, 2 members will be appointed by the Senate, with 1 member appointed by both leaders of each caucus. 2 members will be appointed by the House, with 1 member appointed by each leader of each caucus. 2 circuit court judges will be appointed to the commission, with 1 representing a county with less than 800,000 people, 1 representing a county with more than 800,000 people. These members will be selected from a list provided by the Michigan Judges Association. 1 member will be representing the law enforcement, will be appointed by a list provided by the Michigan Sheriff's Association. And 1 member who represents the prosecuting attorneys in Michigan, appointed by the Michigan Prosecutors Association. There will be 1 criminal defense attorney appointed by the governor, 1 member who represents a nonprofit that serves victims and advocates for victims, who would be appointed by the governor, with the hope and point to strengthen the voice of victims on the commission. The 5 non-voting members include the chair, attorney general or their designee, an individual who was previously incarcerated, a mental health professional, and the director of the Michigan Department of Corrections or their designee. Another change we made into the bill was in Section 3 in how we make the appointments to the commission. Previously, those came from the governor. Now they'll be mostly provided by the legislature. The defense attorney and victims' rights advocate will be selected from a list of 3 names submitted by the Senate Majority Leader and the Senate Minority Leader, with 1 leader submitting 3 names for the defense attorney and 1 leader submitting names for the victims' rights advocates. And then down the line, when those positions become vacant, they kind of switch. This provides a balance of power within the commission to allow legislators from all the caucuses to have a say in who serves on the commission, as well as the defense attorneys and the victims' rights advocates are 2 of the voting members on the commission. The governor would appoint the chairperson with advice and consent from the Senate. And the commission remains housed within the Legislative Council so that we can empower the legislature with the best policy from policy experts to make the decisions regarding the sentencing guidelines in Michigan. The H2 substitute for House Bill 4384 clarifies that the focus of the Commission's role is only on criminal sentencing guidelines and nothing else. The H2 substitute also clarifies that the Commission will only make policy recommendations and clarifies that the Commission's reporting requirements to the legislature, the governor, and the Michigan Supreme Court. And lastly, the substitute makes clear that existing sentences are not affected by any recommendations made by the Commission, and that the Commission will make no recommendations related to sentencing credits. And that is all.
We do have a question, Representative Devendorf.
I'm going to be easy on you. Thank you for testifying to this legislation. It's very important, and I am in support of it. The only question I have is related to the actual representation on the Sentencing Commission. I see a lot in the way of presenting the folks involved in the process, and I only see 1 person that is, 2 people if we're talking about the victim's rights advocate representing the victim directly, but I only see 1 person that is directly impacted by sentencing. Are there any plans to increase the representation of those directly impacted by sentencing, considering 1 person's experience is not the same as another person's experience depending on where they're sentenced out of, and also what their experience has been throughout the system due to systemic issues?
Thank you, Representative. First, we do appreciate the importance of having victims on the commission and having their voices heard throughout this process as we look at sentences. And we know that as we get the lists of people that are going to be coming onto the commission, that it'll be important to get the right folks, right? And we hope that the people that are coming forward to serve on the commission and have their names forward will, for one, be representative of a broad swath of people. And we do recognize that not one individual can represent everybody, but in an attempt to constrain the size of the commission and not have it be 20, 30, 40 people, that's kind of why we made that decision to narrow it down to that one individual, knowing that other folks throughout this process can advocate in different ways for folks that have been harmed by crimes, knowing that they don't specifically advocate for the person that has been harmed. But that is kind of where we ended up at the legislation. I'm not the representative, so I can't necessarily speak to any changes that might be made down the line, but that's kind of how we got to where we were.
You're doing a great job. I would just encourage us to try to look for, in terms of the future, at really strong engagement with formerly incarcerated populations so that we get more perspectives, both for victims and with victims, and especially with formerly incarcerated individuals. But thank you very much for this.
Thank you, Representative.
Representative Breen.
Thank you, Madam Chair. It's my understanding that this bill has undergone approximately 800 million
I think it was 15
renovations, if you will.
drafts, but I'm not
Okay.
sure.
So it's my understanding this was negotiated with the other caucus, which I think is great. I see that you removed the chair of judiciary as a voting member. Personally, I'm okay with that. And that you added back in somebody specifically to represent victims or victims advocates. Given the number of revisions that this has gone through, do you anticipate any more changes between here and the floor or the Senate?
I personally don't anticipate any, but I can check with Rep. Ayash and see where I haven't been involved in most recent conversations, if there has been any conversations in the last couple of days, so I can check with him. But I don't believe there's going to be any changes to it as it goes from here to the floor. We worked with all the stakeholders at the table here, trying to put together a bill that has everyone represented in some capacity who's involved with the sentencing process. So I think what has been negotiated between all of the people, all the stakeholders involved, is the product we have, and that's what we're hope to be moving forward with.
And again, just to verify, put on the record, this is just to make recommendations to the legislature. Will ultimately
Yes.
vote on what the penalties, if any, should be. Okay.
Absolutely.
Thank you so much.
We do have cards on these bills, and the clerk will make sure that those are recorded in our record. I will take a motion to adopt the H2 substitute for HB 4173. Representative Devendorf moves. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat. Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 4 pass. The substitute H2 to House Bill 4173 is adopted.
Thank you. I'll take a motion with recommendation as I'll take a motion to report HB 4173 with recommendation as substitute H2 from Representative Breen. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass.
Bazat. Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 1 nay, 3 pass. House Bill 4173 is reported with recommendation as substitute H2.
Thank you. Representative Arbit moves to adopt the H2 substitute for HB 4384. Would the clerk please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat, Harris,
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 4 pass. The substitute H2 is adopted.
Representative Cerniglu moves to report HB 4384 with recommendation as substitute H2. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Green. Aye. Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
Pass.
Bazat, Harris,
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 1 nay, 3 pass. House Bill 4384 is reported with recommendation as substitute H2.
Thank you. And we now have a couple of housekeeping matters to take care of here. We have a vote to refer House Bill 4387, which is known commonly as Justice for Ally, to Families, Children, and Seniors Committee. I'll take a motion to refer the bill to the Committee on Families, Children, and Seniors. Representative Young moves. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Green,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Pass.
Bazat, Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 11 yeas, 0 nays, 1 pass. House Bill 4387 is referred to the Committee on Families, Children, and Seniors.
Thank you. We'll now take a vote on referring Senate Bill 72 to Health Policy. This is part of the Sexual Assault Prevention and Accountability Package. Representative Breen moves. Would the clerk please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Green,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. Senate Bill 72 is referred to the Committee on Health Policy.
Thank you, Madam Chair. And we will now return to testimony on hate crimes. House Bills 4474, 4475, 4476, and 4477. Jadana Dingus, would you like to join us up here? And please get started whenever you're ready.
Thank you, Chair Hope. Good morning. My name is Jadana Dingus. I was the target of ethnic intimidation in 2021. I'm here today to offer my support for House Bill 4474. I am so grateful for the hard work and dedication of the Ethnic Intimidation Amendment Work Group, which I formed in 2021. I invited the Grosse Pointe and Harper Woods NAACP to the table, along with Attorney General Dana Nessel's office and the Wayne County Prosecutor's Office, just to name a few. 95% of the language in House Bill 4474 came out of that work, the work that the work group did. I'd also like to thank AG Nessel, Prosecutor Worthy, and Representative Arbit for the work that they've done and the work that they will continue to do to make every citizen of Michigan safe from hate crimes. As it currently stands, this bill protects Michigan citizens from experiencing the anguish visited upon my family and I in the early months of 2021. At that time, my neighbor hung a Ku Klux Klan flag in the window of his home to intimidate my family and I. We had recently installed a surveillance camera on the outside of our home to track suspicious activity after someone placed a full can of gasoline in an empty recycle bin which was adjacent to our home. Our neighbor told the Grosse Pointe Park Police Department that he put the flag up to stop us from seeing inside his home, even after the police assured him that the angle of the camera blocked a line of vision into his home. He insisted that the Klan flag was necessary because he had no curtains. It took a local news reporter pressuring the police department to eventually convince my neighbor to remove this recognized symbol of hatred against black people from his window. To illustrate the short distance between our homes, if you placed a broomstick on his windowsill, the bristles would touch my windowsill. My daughter and I were terrified. My daughter would awaken from her sleep with nightmares of our neighbor shooting through the dining room window and killing us. She was afraid to be in our house alone. Imagine trying to comfort your only child, but knowing you couldn't protect her. This fact made me unnerved as well as angry. He couldn't be prosecuted because he did not harm us physically or deface our property. We decided to move because I valued my daughter's mental health and emotional health and the security of our family more than our right to the pursuit of happiness. Had this legislation been in place, Wayne County Prosecutor Kim Worthy, who testified earlier, would have been able to bring charges against my neighbor. He would have been held accountable for his actions, and my family would have been protected by state law. I want to ensure that no other Michigan resident is unprotected from intimidation, harassment, menacing, and unnerving because a fellow citizen hates them because of the color of their skin. I want the same protection for other non-minority majority communities that have historically suffered racial hatred, and those in the LGBTQI+ community who are attacked because of who they are and who they love. We know that there's an intersectionality in the LGBTQI+ community and racially as well. The number one group attacked in the LGBTQI+ community are Black trans women, attacked and killed. I would like to thank the committee chair, Committee Chair Hope, and the members of this committee for allowing me to speak today. And I would like to acknowledge this honorable body for its dedication to overseeing criminal laws in the state in deliberate fairness. Thank you.
Thank you for sharing your story. Somehow we ended up with time. However, I believe that our next folks to testify are going to join us in the afternoon. So, Representative Filler moves to excuse Representative Bizot. And we are going to go at ease.